Yes, sir, I can hear you clear.
Okay. We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Okay. So this situation stemmed from arrest from March 8, 2021, from a lawful arrest without a warrant. Um, uh, Sorry about that. Okay. This is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime that took place prior to the unlawful traffic stop. Okay. The state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis exist to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. Um, for one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. Uh, an injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, well, I'll just repeat what I said. So this situation happened from an unlawful traffic stop um, without a warrant or a concrete injury from an injured party prior to the traffic stop. I want to make a note also that the traffic stop and the other offense of possession of marijuana was dismissed back in 2021, approximately around the time when the case was first initiated. I did upload and file on the record evidence of that notice of.
Welcome back, everyone. Today's case takes us straight into the Lone Star State, where a self-proclaimed Moorish sovereign citizen is about to take on Judge Christopher Morales. This isn't just another routine hearing. This is round 2 of an ongoing courtroom clash. The defendant, Mr. Antoine Jermaine Davis Bay, previously had his motion to dismiss denied, but today he's trying to overturn that ruling with a motion for reconsideration. Now, if you've seen these sovereign citizen cases before, you already know how this tends to go. Lots of pseudo-legal jargon, strange constitutional interpretations, and arguments that sound impressive until you realize they make absolutely no legal sense. But stay tuned, because Judge Morales has the patience of a saint, up to a point. Let's dive in and see how long it takes for this legal roller coaster to go on.
Also, I want to point out the fact that this is a case of hypothetical suspicion versus a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for a broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, in Texas, arrest or search without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01, Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop, and then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to um, prosecute a traffic citation against me. And also the adjoining.
From the start, we can tell where this is headed. The defendant is arguing that his entire arrest was unlawful because there was no injured party and no sworn affidavit. This is textbook sovereign citizen rhetoric. They love to claim that unless someone is physically harmed, there's no real crime. But that's not how the law works. Probable cause doesn't require someone to be injured. It just means the officer had a reasonable basis to believe a crime occurred. Also, affidavits of probable cause aren't required for every arrest. Traffic stops fall under a completely different category. So basically, Mr. Davis Bay is swinging at...
The Amendment requires fair treatment through the normal judicial system, protects against, due process clause protects against arbitrary government actions, including unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer.
Here's where things get interesting. Davis Bay tries to argue that since his marijuana charge was dismissed, every other part of the traffic stop should be thrown out too. That's a massive leap. In legal terms, each charge stands or falls on its own merits. If one gets dismissed, the others don't automatically vanish. Imagine getting pulled over for speeding and also having an expired license. If the speeding ticket gets tossed, that doesn't magically make your license valid. But that's the kind of magical thinking sovereign citizens often rely on. They connect dots that legally don't exist.
Which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report. And it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure, Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony or affidavit of probable cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Well, this was all inside my motion as exhibits and as a brief.
Allegations made by the state were not contained in.
Comes the predictable Terry versus Ohio reference. If I had $1 for every sovereign citizen who quotes that case without actually reading it, I could probably pay all their court fines. Terry versus Ohio does deal with reasonable suspicion, but it doesn't mean cops can't stop you unless a full-blown crime is happening. It just sets the standard for brief detentions. Davis Bay keeps calling this a hypothetical suspicion, but the officer clearly saw something that warranted the stop, meaning it's perfectly lawful under the Fourth Amendment. It's like watching someone argue a YouTube comment section out loud in court.
As a result of a warrantless arrest and search must be suppressed, case dismissed under the fruit of poisonous tree doctrine, and that's Wong Sun versus United States, followed by citation. This doctrine,
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
yes, ma'am. Yes, sir. Wong Sun is WONG, first name, last name Sun, SUN. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well.
Now we're into constitutional territory. He starts invoking the 5th and 14th Amendments and the Texas Constitution, claiming due process violations. But due process doesn't mean the court has to agree with me. It means you get notice, a fair hearing, and a chance to defend yourself, which he's literally doing right now. What's really happening is that he's trying to repackage the same failed arguments under a new label, hoping the word constitutional will magically make it work. Spoiler, it won't. Sovereign citizens love throwing constitutional buzzwords around, but without context, it's like trying to cast spells with a broken
Warrantless arrests, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state and the failed documentation that the prosecutor failed to provide with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search. So I do compel that full discovery, and I do request that this.
And here we have the moment of truth. The judge steps in and reminds him to stay within the scope of the hearing. Translation, you're way off topic, buddy. The judge is trying to keep the discussion relevant to the actual motion for reconsideration, but Davis Bay insists on re-arguing the entire case from scratch. Judges hate this. It wastes time and shows the defendant doesn't understand procedure. At this point, you can almost hear Judge Morales silently praying for patience. The courtroom may be calm, but this is the legal equivalent of watching someone try.
He was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was.
Will you
Okay.
spell that, sir?
Last bayby@gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address. The state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did
So
you
the
request it? Who did you request it from?
the Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by defense, again, as I just made clear, the defense has had access to the discovery since, at the very least, October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor. So he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, the officer had a on-view offense for a traffic citation, which was speeding. The officer attempted
invokes the fruit of the poisonous tree doctrine, one of the most misunderstood legal concepts by sovereign citizens. Yes, it's a real thing, but it only applies when a constitutional violation actually occurred. If the original traffic stop was valid, and nothing here shows it wasn't, then there's no poisonous tree. The judge even has to pause so the court reporter can get the spelling right on Wong Sun versus United States. You can tell by the tone. The courtroom knows this